lost his wife and 9 of his children. Altogether, he lost 31 family members. His son lost his wife and his 3 children, including his infant son, who we saw decapitated. There's been a global movement to hold human rights abusers from all over the world accountable wherever they are, especially when their own countries won't hold them accountable. Since the 80s, when CCR sort of rediscovered the Alien Tort Claims Act, also known as the Alien Tort Statute, which allows non-citizens to bring claims in the United States courts against defendants from anywhere for violations of customary international law, for human rights violations. So basically, when human rights violators have come to the U.S., non-citizens have been able to sue them and hold them accountable in U.S. courts. This has been supplemented by another statute, the Torture Victims Protection Act, which Congress passed in 1992, which allows non-citizens and citizens to sue for torture and what's called extrajudicial killings. It's clear in the United States that international law is a part of U.S. law, and that when the courts have jurisdictions over people in the United States, so when a human rights violator comes to the United States, that person can be held accountable in U.S. courts for their acts wherever they occurred. This is primarily known as the concept of universal jurisdiction, and a lot of countries allow for this concept, although in most countries the claims are criminal in nature. The defendant can actually be placed in jail, or can be arrested, can be sentenced. Here in the United States, although there could be the opportunity to have criminal suits against defendants, what private citizens can do or non-citizens can do is hold them liable for damages in U.S. courts. In other words, they won't be able to be sentenced for their crimes, but they can at least be held accountable for their crimes and assess damages to the people who they've harmed, to the victims of their crimes.
The Palestinian victims of human rights violations are not different from any other victims. They have the same rights, and they have to be treated equally and fairly by those national systems, including the U.S. justice system.
There's no reason at all that human rights violators from El Salvador should be held liable for their human rights violations, and human rights violators from Israel should not.
In August of 2005, the Israeli parliament approved a legislation, which is an amendment to the Civil Wrongs Act, which eventually immunized Israeli officers and the State of Israel from any civil action to be brought against them by Palestinians who were injured, killed by operations that were conducted by the Israeli army in the occupied Palestinian territory.
The Sabra and Shatila was essentially after the Israelis had invaded Lebanon and had advanced up to Beirut and surrounded Beirut after pounding it with artillery and aircraft bombardment, all kinds of prohibited weapons, phosphorus bombs. An agreement was reached whereby the PLO fighters in Beirut would evacuate Beirut via Greece. Part of the agreement is that the Israelis would not allow the flangist forces of the Lebanese forces into West Beirut, because here was a civilian population that was totally unprotected. And the Israelis reneged on that promise. What they did was they surrounded Sabra and Shatila, and they allowed the Lebanese forces to go in while the Israelis lit up the sky with flares, prevented anybody from fleeing from Sabra and Shatila, and this orgy of killing took place over several nights in the camps. We learned about the appointment of a former Israeli general whose name was Amos Yaron to become the military attaché of Israel at the Israeli embassy in Washington. When we learned that the individual who had been appointed had been a person who had been found responsible by an Israeli commission investigating the Sabra and Shatila massacre, we were astounded. We were astounded because, number one, that they would appoint a person with such a background for such an important position, and number two, that the United States would accept such a person as the military attaché to Washington. And what we determined was basically that Amos Yaron had been a fall guy for the Sharon and Begin governments in the Sabra and Shatila massacre. He had been the point person in this Israeli investigation, and that he was now being rewarded with this position as Israeli military attaché in Washington. We requested from the United States government that they not receive his accreditation as the military attaché in Washington. We got no satisfaction in that request. So we began an effort to have him removed. We contacted Canada, because whoever is the Israeli military attaché to the United States is also military attaché to Canada. And we were successful in getting the Canadians to not accept Yaron as the military attaché to Canada. We also wrote to all the members of the United Nations, pointing out the fact that the United States was accepting a person who was essentially a war criminal. We filed a lawsuit on behalf of some of the survivors of Sabra and Shatila in the United States District Court. We were represented in this by Professor Francis Boyle of the University of Illinois Law School. Motions to dismiss by Yaron's attorneys were successful before the federal judge, who held that Yaron had immunity because he was a diplomat. We also led a public information campaign with op-ed pieces that were published in the Detroit Free Press, in newspapers in Texas, in Florida, and the gist of this campaign was, here Israel itself had a commission that found Yaron to bear responsibility in the Sabra and Shatila massacre, and he was being accepted with open arms by the United States to be a diplomat in Washington. We also, as part of our public information campaign, had placards put in the Washington, D.C. subway system with Yaron's picture, a picture of the victims of Sabra and Shatila, and a statement about the fact that Yaron had been found responsible by this Israeli commission in its report, and yet the United States was accepting Yaron as a diplomat in Washington. Well, he was removed by agreement between the Israelis and the United States before his term was to expire because of this pressure.
Moshe Alon is a fellow at the Washington Institute in Washington, D.C., so he's been in the U.S. for months, and he was actually he was most recently the chief of staff of the IDF, the Israeli Defense Forces, until June of 2005. But in 1996, he headed the intelligence branch of the IDF, so that he was responsible for the intelligence and some of the cross-border operations. At the time, Israel was occupying southern Lebanon, and in April of 1996, they conducted what was called Operation Grapes of Wrath, where they were shelling the civilian population in southern Lebanon, trying to force them out of southern Lebanon. Hundreds and hundreds, at least 800 refugees fled to the UN facility, the UN compound that had been set up in southern Lebanon to basically monitor the occupation. This is the UN compound was north of the occupied territory. So refugees had fled from their villages in southern Lebanon, and those who didn't have the money or the means to go all the way to Beirut or other places had to go to the UN compound in Qana. So about 800 refugees were there, and around April 11th, the IDF started shelling the villages. They were announcing to the villagers to get out of their homes. The UN compound had been set up in 1978. It was very clear that it was there. The IDF knew it was there. About 800 refugees fled to the compound, and on April 18th, the IDF actually attacked the compound. Over 100 civilians were killed. 4 UN workers were also injured, in addition to the hundreds of others who lost limbs and suffered other horrendous injuries. We represent Ali Sadallah Bilhas, who lost his wife and 9 of his children. Altogether, he lost 31 family members. His son lost his wife and his 3 children, including his infant son, who we saw decapitated. We represent another plaintiff who lost his wife and 3 children, and 4 others who suffered disabling injuries. There was about a minute or 2 into the shelling, the UN compound personnel actually contacted the IDF and said, "You're shelling a UN compound." The shelling continued for 17 or 18 more minutes before they stopped. Amnesty International, Human Rights Watch, the UN all investigated the incident. The UN found that it was unlikely that it was error. This was their finding after significant pressure by the U.S. and Israel, when the findings were reportedly to be that it was clearly an intentional attack on the UN compound. Under international law, it is clearly prohibited to attack civilians in any way. It is clearly prohibited to attack UN facilities. So the case is against Moshe Yaalon for his role in participating in the decision to bomb the compound, to target the compound, and also for his command responsibility for those people under him, under his authority, who made the decision or who implemented the decision, and also for his responsibility in not punishing anyone for this incident. The complaint alleges he's culpable for war crimes, crimes against humanity, extrajudicial killings, and for cruel, inhuman, degrading treatment and punishment. So despite the fact that the UN, within a week of the Kana incident, the UN General Assembly called for Israel to be responsible for compensating these victims, despite the fact that it's been almost 10 years since the incident, the victims have had no compensation. There's been no accountability against any Israeli officials for this incident. There is really no place else for the victims to go. So finally, they've been able to, at least have an attempt to achieve justice in a U.S. court, because Moshe Yaalon was in the U.S. in Washington, D.C., so there's jurisdiction over him. Moshe Yaalon is represented by a law firm who has appeared in the litigation and will be moving to dismiss the case. It doesn't matter whether or not he is here or whether or not he is back in Israel. The case still moves forward against him. In this case, it was clear that this incident, clear internationally that this incident violated international human rights, and that it was unlawful.
The other case that was also brought in the past, and again it was an attempt to initiate a criminal prosecution process, was in Belgium, where victims of Sabra and Shatila massacres, some of them have been organized, and again cooperation between Lebanese and European attorneys have put together a strong claim and filed it to Belgium Attorney General, who had the right, and according to Belgium law, to initiate such prosecution based on an investigation and the evidence put in front of him. While this case went all the way up to the higher court in Belgium and subsequently blocked the ability of the victims at least to pursue the case against former defense minister at the time, Ariel Sharon. It emphasized and was a landmark case in a sense that it had brought to the legal systems the importance of addressing those human rights violations, especially where those victims were never been compensated, were never been recovered for their suffering, for the damage that they that they had during the 1982 Israeli invasion to Lebanon. An attempt by, again, Palestinian Center for Human Rights with Swiss attorneys, and again brought a case against Israeli officials who were complicit and in charge of the violations of international humanitarian law and international human rights law for demolishing Palestinian homes as well as torturing Palestinians in the mid-90s and onward. Those cases have been submitted to the Swiss Attorney General and been reviewed. Unfortunately, some of those cases have not been successful, largely because they raise a very difficult political problem with regard to allowing foreign jurisdiction to hear cases related to foreign nationals when there was no immediate link between the victim or the perpetrators to the country where the victims were pursuing the actions. And that is why there is so need now to continue with the process of seeking justice in every single legal system that would allow such jurisdiction, whether in civil and criminal. Most recent case was the case of trying to prosecute an Israeli official who was formerly the head of the Southern Command in the Israeli army, Doron Almog. And this case, which was brought to a British magistrate, was based on substantial evidence and a lot of testimonies charging Doron Almog for war crimes, for demolishing over 60 houses in the city of Rafah in the occupied Gaza Strip, when he was the commander of over in the time that the massive home demolitions occurred. And the Palestinian Center for Human Rights, associated or assisted by British attorneys, filed the case to the court and succeeded in getting an arrest warrant against Doron Almog, who was visiting to speak at an event in the UK, and actually the British police were trying to enforce the arrest warrant and waited to Doron Almog at the airport, but Doron Almog was tipped by the Israeli embassy that there is such a measure against him in the UK, and advised him not to disembark the plane, and as a result he escaped and returned back on the same flight to Israel, evading British legal system review of his case, and again an attempt to hold him accountable. There was a reluctance on the side of international community, generally speaking, to get more involved in pursuing human rights claims against human rights violators and abusers. Maybe except for limited numbers of cases, particularly with regard to genocide that were committed in Rwanda, in Bosnia, and other places, there were more tribunals that were created in order to bring to trial those who were violating human rights in a large scale. However, the criminal aspect of it, the universal jurisdiction and the criminal prosecution, has been always limited to these tribunals, and later on to the limitations that were posed by different states that did not ratify the ICC, that is the statute, the Rome Statute of 1998, which created the International Criminal Court. Although now there might be more cases brought to the ICC in The Hague to hold officials, people who acted under color of law against victims of in war, in armed conflict, but also in other situations, like under dictatorships, could bring such claims, and they could be prosecuted in The Hague. On the other hand, many other countries still have their own universal jurisdiction articles or provisions and laws that allowed victims of human rights violations from all over the world to use their legal system in order to pursue justice. There were several attempts and cases that were brought in different countries, and particularly in European countries, where victims of human rights violations and victims of war and armed conflicts who were subjected to war crimes by different armies, brought cases in Europe, in different European countries that had certain provisions and allowed them to enforce and to invoke the universal jurisdiction authority and hear such cases and lawsuits. In Britain, there were many cases that were brought by Afghans who were victims of warlords, for example, during the Civil War. And they were successful using the 1955 Geneva Conventions Act. In Brussels and in other countries, there were some attempts to bring such cases.